It was a stormy SATAWU protest, one of the worst by contemporary standards. Hawkers, traders and vendors targeted, shops and cars also damaged. A series of court battles between 8 claimants and the union followed. Today, the court called for a balancing act in the exercising of constitutionally protected rights.
Liability for damages arising from that action is borne by the organizations that are responsible for setting in motion the events that give rise to the loss suffered.
It is something good because when any riot or anything uprising comes or anything happens, must be paid for.
They break everybody's glasses, but there wasn't enough police or the military or anybody, so we all affected with that day.
It's a landmark judgment that sets a precedent for the entire labor movement. Unions will now have to be liable for their actions during strikes.
It's a disaster to the labor movement. As much as the judgment says no, it doesn't limit the right to strike. In a way, it does, because it will always be used as a precedent.
Unions shouldn't be held responsible, in particular for acts such as those when there is no proof linking the union directly to those acts of vandalism which we have condemned.
The constitutional issues are done and dusted, but the union will return to the Western Cape High Court to argue the specific amount of the damages incurred. SABC News, Johannesburg.